Jefferson County Court at Law number 2 is now in session. Well, we was getting ready to call Mr. Rojas and he just got off. Oh, well. We'll go to another one. Is John Washington here?
No, Your Honor, he's not here so far.
Okay. And the Aquarius Lewis is not here either. That's on the motion to revoke probation. Okay. We'll wait till, oh wait, there's Mr. Rojas again, I guess. Okay. Jefferson County Court of Law number 2 is back in session. First case that we have is Isaiah J. Blewett, cause numbers 324832, cause number 324970, and cause number 330973. All three cases are styled the state of Texas versus Isaiah J. Blewett. Mr. Blewett, you can take your mic off of mute.
Yes, sir.
Mr. Blewett, how are you doing?
I'm good.
That's good. Mr. Blewett, you're here. You're represented by your attorney, Attorney Charles Rojas, who is also appearing via Zoom. Attorney Rojas, how are you doing?
Doing well, Judge. Thank you.
Attorney Rojas, what's your announcement in Mr. Blewett's cases?
Judge, he's got 2 motions to revoke and a new case. We need to set the motions for hearings and the new case for a trial.
Okay, give us, we don't have, give him about 60 days on those. Okay, that's for the, that's for the that's for the MTRPs. Now the third case is gonna be on the, that's a set for a trial, that'll be on a different date. What's August the 5th? What day of the week is that? Is that a Friday? Okay.
We can do May 22 for the trial.
Okay. Mr. Rojas, the 2 cases that are motions to revoke, they will be set for August the 5th of 2022. And the third case, which is set for trial, will be set for August 22nd?
Yes, sir.
For August 22nd of 2022. And Mr.
Sorry to interrupt, Judge.
Hmm?
If the court would consider allowing the state to proceed to trial first before the MTRP, I think that the outcome of the trial will be determinative of the MTRP.
Mr. Rojas, did you hear that?
Yes, sir. I have no objection to that.
Okay, so hold on, let's do this here. So we're gonna set it for trial on August the 22nd. And what we'll do, well, let's do this here. We'll set it for trial on we'll set all 3 of them on August 22nd. So we know that it's set for trial. And then depending on what happens with the trial, we'll get the settings on the other two cases.
Thank you, Judge.
Is that fine, Mr. Rojas?
Yes, sir. That's fine.
Better get up. Okay. So these cases will be set on August 22nd of 2022. Mr. Rojas, your recess will be sent to you. And Mr. Blewett,
Yes, sir.
the recess for August 22nd, 2022, your attorney will be given notice and your bondsman will get notice. Stay in contact with your attorney and your bondsman.
Yes, sir.
Okay, and you're excused, you're free to go, you have a blessed day. And Mr. Rojas, I think these are your only cases today, is that
Yes, sir.
correct?
Yes, sir.
Okay, you're excused as well, and you have a blessed day.
Thank you,
All right,
Judge. You as
thank
well.
y'all, Judge. Appreciate y'all.
You what? You welcome. we're gonna hear your case. Okay, next case is cause number 329564, case of style the state of Texas versus John Beard. That's one of Miss Nelson cases. Case is on the announcement docket. Ms. Provo, would you please come forward with your client? This is cause number 329564. Case is style the state of Texas versus John Adam Beard. Mr. Beard, is that your full name?
Yes, sir.
How you doing, Mr. Beard?
I'm good, how are you?
I'm doing fine. Thanks for asking. Mr. Beard, you're here represented by your attorney,
Yes.
Attorney Marvel Provo. Attorney Provo, how are you doing?
I'm gonna find out.
And the state is represented by Attorney Tommy Coleman.
Yes,
Attorney
sir.
Coleman, how are you doing?
Doing good, Your Honor.
All right. Okay. And okay, so Ms. Provo, what is your announcement in Mr. Beard case?
Your Honor, we would like to have at least 30 days to people on the announcement.
Announcement, okay,
But
No.
we haven't got an offer yet.
No objection,
so
Judge.
we need to-
okay, give us a reset.
July the 8th or the 15th.
Let's say July, which one?
8th or the 15th.
Oh, which one?
The 15th.
Okay, this case is gonna be reset to July 15th of 2022. Ms. Provo, you can sign for your reset. Once you get your reset from your attorney, Mr. Beard, you'll be free to go and you have a blessed day.
Thank you, sir.
You're welcome. Not- Okay, well, yeah, she was arrested. We're gonna reset Miss Tanya Nutter on the announcement docket for 60 days. Yes. And let's see, she was reset. arrested in court. Okay, this is cause number 331-042. Case is style of State of Texas versus Leo Randall. Hold on, before we do that. All right, Christopher Anderson, you come forward. Print off, see if we have a motion to withdraw in that case.
I would judge your.
There's not one? What I see, motion to withdraw granted.
But that was on Bruce Smith.
Oh,
Then we appointed McIntosh after that.
okay.
Must have missed that one, 'cause I didn't-
So he didn't file that?
I'm gonna check it.
We're trying to see if your attorney filed the motion to withdraw. He's been filing motion to withdrawals in his case because he's moving to Montana. And so just have to see, we're gonna contact him and see if he's gonna,
I tried, I left him a message. You can ask.
I think, okay, just have a seat. Mr. Coates, stand on that X, your attorney had asked for your case to be reset. Okay, your case is gonna be reset. And stay in contact with your attorney. Your attorney is currently in court in Orange County. And so we'll give you a number. She'll give you a number, okay? And don't throw it away.
No.
Because we should have had a number on that, the first time he got appointed. I think we probably gave it to you. Okay, we're gonna give you the number. Just hold on. And thanks for being patient with us. And once you get your reset or with the phone number, you'll be free to go and you have a blessed day. Okay. Right. What we may just go ahead on and do our bond forfeitures. Okay. And let me do this here. Okay, the court is back in session in the motion to revoke probation docket. Next case is cause number 323886. Case is styled the state of Texas versus John Scott Washington Jr. John Scott Washington Jr. Was scheduled to be in court this morning at 9 a.m. for the court's motion to revoke probation docket. At or about 9 a.m., the court's bailiff called the name of John Washington, and John Washington did not answer. John Washington has not appeared in court since the court has been in session. The time now is 9:40 a.m. on today's date. Ms. Bailiff, would you please call the name of John Washington?
John Washington. John Washington. Call John Washington. No response, Your Honor.
Okay. John Washington's name was just called at the courthouse door by the court's bailiff. John Washington did not answer. A reasonable time has passed to give Mr. Washington an opportunity to appear in court. He has not appeared in court. State, do you have a motion?
State moves to bond forfeiture, Judge.
That motion will be granted. John Washington's bond will be forfeited and a warrant shall be issued for his arrest. Next case is cause number 327360. Case is style of state of Texas versus Jaquarius Marquez Lewis. Jaquarius Lewis was scheduled to be in court this morning at 9 a.m. for the court's motion to revoke probation docket. At or about 9 a.m., the court's bailiff called Jaquarius Lewis' name at the courthouse door. Jaquarius Lewis did not answer. Ms. Bailiff, would you please call the name of Jaquarius Lewis at the courthouse door?
No response, Your Honor.
Jaquarius Lewis' name was just called again at the courthouse door by the court's bailiff at 9:41 a.m. Jaquarius Lewis did not answer. A reasonable time has passed to give Jaquarius Lewis an opportunity to appear in the court. He has not appeared in court. State, do you have a motion?
State moves to bond forfeiture, Judge.
That motion will be granted. Warrant shall be issued for arrest of Jaquarius Lewis, and a warrant and a bond shall be forfeited in clause number 327360. Now, the case court will move to the announcement docket, which was also scheduled at 9 a.m. on today's date of June 30, 2022. And the next case is clause number 330472, cases style of state of Texas versus David Mitchell. David Mitchell was scheduled to be in court this morning at 9 a.m. for the court's announcement docket. At or about 9 a.m., the court's bailiff called the name of David Mitchell. David Mitchell did not answer. David Mitchell has not appeared in court since the court's been in session. A reasonable time has passed to give Mr. Mitchell an opportunity to appear in court. He has not appeared in court. Ms. Bailey, would you please call the name of David Mitchell?
David Mitchell. David Mitchell. No response.
Okay, David Mitchell's name was just called again by the court's bailiff at the courthouse door. David Mitchell did not answer. Reasonable time has passed to give David Mitchell an opportunity to appear. David Mitchell has not appeared in court. State, do you have a motion?
State moves to bond forfeiture, Judge.
That motion will be granted. David Mitchell bond will be forfeited and a warrant shall be issued for his arrest. And Mr. Doyle, you excuse, and you have a blessed day.
Thank you.
Okay. Our next case is cause number 328148. Case of style state of Texas versus Christopher L. Anderson. Mr. Anderson, would you please come forward? And we got in chat. Will we have been contacting Mr. McIntosh?
They were gonna text them to get your vision.
Oh, he is?
Well,
Okay,
they were gonna text them.
Mr. Anderson, they are texting your attorney to see if he can appear via Zoom. So he may be doing that in the next few minutes, okay? Okay, you may be seated.
Current state has a motion with regard to Mr. Harmon. The court will entertain it.
Oh. That's Mr.
This is Lawrence's client.
Mr. Lawrence, class?
Yeah.
Mr. Lawrence? Looks like they're trying to work out something.
Yes, Your Honor.
Okay. The state said they have a motion in regards to your client, Mr. Harmon.
Yes, he's here.
I say, Mr. Harmon, would you please come forward?
We're in the process of adjusting things. Ms. Nelson and I are adjusting things on the plea.
Okay.
Okay, Judge, Your Honor, pursuant to the standard conditions of pretrial release, we ask that the court order that this defendant be randomly drug tested today.
I didn't understand.
He wants your client to be randomly drug tested.
Now,
Yes, he just, I guess the
There's been
Probation
some
officer.
indications, indicators, Judge, that were observed by a number of people that this defendant may be under the influence.
Okay, well, that could have a bearing on whether or not he, okay. Mr. Harmon, Mr. Gilliam, just follow that, follow Mr. Gilliam. Mr. Harmon, just right here, just Mr. Gilliam. Okay,
we'll still
Article 1.24 of Texas Code of Criminal Procedure. All proceedings and trials shall be held public. However, pursuant to Lilly versus State, I just need to do this. Mr. Harmon, Mr. Lawrence, do you have a minute? Mr. Lawrence, come on, step on up.
Yes, Your Honor.
Let me get that to you. Now, before you go do anything now, this is cause number three three one seven six eight. The case is filed State of Texas versus Mr. Harmon, or Mr. J. Harmon, or Mr. Jermaine Harmon. Mr. Harmon, is that your full name? How you doing, Mr. Harmon?
Good.
Okay, now, first thing, Mr. Harmon, the court has policies and procedures regarding the dress code. And, well, it's all over the doors. Okay. It's first time being in court? Okay. So the court is going to excuse you this time, but anytime you come to court, you need to dress appropriately. Okay. Now, the second thing is all proceedings and trials, the proceedings and trials in all courts shall be public. However, pursuant to Lilly versus State 365 Southwest 3rd 321, the right to public trial is not absolute and may be outweighed by other competing rights and interests, such as interest in security, preventing the disclosure of non-public information, or ensuring that the defendant receives a fair trial. Now, we have a test that the court state motion for, and the court audited, and based on that, Mr. Lawrence, the information in that test may be, it will be disclosed over the public way on YouTube. And so if you would like to prevent the disclosure of this non-public information, the court will entertain that motion.
In fact, Judge, the state will make that motion.
Pardon?
The state will make that motion, Judge.
Yes, Your Honor, we would like to
Okay,
prevent the disclosure.
okay, so the parties seeking to close the hearing have advanced an overriding interest that is likely to be prejudiced. Disclosure is no broader than necessary to protect the interest, and the trial court have considered reasonable alternatives to closing the proceeding, and the court makes the finding, and these findings are adequate to protect the defendant's interest. Now, Mr. Anderson, would you step out for a moment? Okay, and so the